Thank you, Madam Clerk. I would like to welcome everybody to the August docket for the Court of Criminal Appeals. I'll take this moment to introduce the panel. To my left, your right, is Tom Greenholtz from Chattanooga. To my right, your left, is Judge Tim Easter from Nashville. He will be sitting with us on the first case, and Judge Ayers will be joining us for the rest of the docket. I am Ross Dyer. I'm from Memphis, Tennessee. All the parties can assume that we have read the briefs and are familiar with the facts of the case and the issues raised. We may or may not have had a chance to look at the record. So if there's specific parts of the record you need us to look to, please let us know that. Obviously, 20 minutes aside. Appellant, if you would like to reserve any rebuttal, please let us know at the outset of your argument. I would also I know we have a full crowd today. Court would expect everyone to keep proper courtroom decorum, or Mr. Deputy back there will kindly ask you to step out with him. With that, if you will call the first case, please.
Yes, Your Honor. State of Tennessee versus James Andrew Didomenico.
And I would just say this, take a point of personal privilege before you start, Mr. Rayburn, to both the defense and to the state. You are lucky I was not motions judge. Brief means brief. So maybe take that into consideration going forward. Thank you. You may begin.
Thank you, Your Honors. My name is Ben Rabin from the Nashville Bar, representing the defendant appellant James Didomenico. I'd like to reserve 3 minutes for rebuttal, please.
All right.
The trial court erred in failing to provide a mistake of fact jury instruction. As the court is aware, this defense negates the culpable mental state and allows the jury to consider the facts as reasonably believed by the defendant, even if he is actually mistaken. Unlike most standards of review on appeal, this is an extremely favorable standard for the defendant. The instruction must be given sua sponte, even without a request from the defendant, which is what happened in this case. There was not a request, but the case law is clear. The trial court must nonetheless give that instruction, even if as long as it is fairly raised by the proof, which is a standard.
So let's answer that question then.
Okay.
How is mistake of fact fairly raised by the proof to the point at which the trial judge is going to know, hey, I need to charge that?
Yes. So several elements of the record, as well as argument by counsel. The proof from really both the defendant and the alleged victim testified that there was a history of consensual sex during arguments, including the prior divorce proceeding and including even the divorce proceeding in question. Mr. Didomenico testified that they had sex several times in recent months, even after a divorce had been filed, and she herself admitted even one of those occasions had happened. And so whether or not she could, despite the fact that they were still in contentious terms, that is one of the reasons.
Okay, before you move on to the others, I'm sorry, let me interrupt you there. So he says several, she says once. So does credibility go into making this? So if the trial judge says it was one time, I believe her versus I believe him, and it was only one time, does that weigh into whether or not mistake of fact should be charged? Or does he just have to blanketly say at least one witness says several, and therefore I have to agree with that?
Credibility is a factor, but the standard is to look at the evidence in the light most favorable to the defendant. So if he's just completely unbelievable, and it just could not possibly be the case, doesn't believe him at all, I think a trial court could make that finding and just say, I just don't believe it, even in the light most favorable, I just don't believe it. But as long as at least it's plausible, as long as it's, again, fairly raised, then that would be afforded to the defendant.
What is the purpose of a mistake of fact defense?
In general, or in this case?
In general.
In general, because we look at obviously the mens rea is one of the critical components, and did the defendant act recklessly, intentionally, and if the defendant believed the facts to be a certain way, then that would negate that mental state that he
Okay,
did
so
not
it's
act
to
recklessly.
negate a culpable mental state.
Yes.
Okay. Would a mistake of fact defense apply when there is no culpable mental state in the statute?
I don't suppose so, if that were to.
In fact, it can't by its terms, right?
I think that would be correct.
And this court has held, at least in a couple of cases that I'm aware, that in strict liability offenses, for example, a mistake of fact defense is not available.
I had not
As
looked
an
at that for
example.
this case because we do have at least a reckless state of mind.
What is the culpable mental state in this case?
At least recklessness, intentional.
What does the statute say the culpable mental state is?
I believe it's to a standard of reckless. I believe that was in the briefing, including by the state.
I think it's that the defendant knows or has reason to know of the victim's condition.
Okay?
I mean, that's the statute, right?
Yes, Your Honor.
Okay, so it looks to me like the statute contains both a subjective mental state, defendant knows of the victim's condition, but it also contains an objective, perhaps not even a mental state, has reason to know, and it's phrased in the alternative. And I'm wondering here if the mental state in the statute that the defendant may be convicted if the defendant has reason to know. I'm wondering how a mistake of fact defense possibly could arise in this case. That's not a culpable mental state that a mistake of fact would tend to contradict.
I would suggest that there still would be a culpable mental state involved. I know there is I don't recall the statute number, but there is the sort of the catch-all statute that says if it's not provided in the statute.
This is specifically provided in the statute. Either the defendant knows or has reason to know, so we don't have need for the gap filler here. So when we have an objective mental state, how does the mistake of fact defense even arise as a matter of law?
I would submit that you could still have that has reason to know to a degree of recklessness. And again, I think that's what the state had argued in their brief.
Sounds like a negligence standard.
I would submit that the reckless would, I mean, the state has argued that. This is not just me saying, I mean, the state's briefing.
But I think I think maybe what I'm trying to get at here, at least here it looks like we're moving away from what the defendant actually knows, subjectively should know, to looking to see what a reasonable person would know in that circumstance, given the surrounding facts and circumstances of the case. And so if we have moved away in the alternative here, away from the subjective mental state, and we all agree that mistake of fact is only relevant to negate a culpable mental state, it looks to me like mistake of fact simply doesn't apply as a matter of law.
I would disagree with that respectfully, Your Honor. I think, in fact, has reason to know. I think you still look at, I mean, you always look at objective facts. And in some ways, I think you could
It's an
look at
objective standard, though, not objective facts. We're looking at an objective standard, not a subjective mental state.
Regardless, I think you can still consider what is the objective situation and what could a reasonable person have seen or what could anybody have seen. I think.
And so how does the defendant's mistake then weigh into it at all? Assuming it to even to be such, how does it weigh into it at all if we're looking to see what a reasonable person would understand from the facts and circumstances?
Well, I think you could say, could a reasonable person be reasonably mistaken? If a reasonable person, for example, the classic example I've heard.
So once again, that's not a mistake of fact on the part of the defendant then. That's a mistake of fact on the part of a reasonable person. So once again, the mistake of fact instruction doesn't arise as a matter of law.
Yeah, I would respectfully disagree. I would submit that it still does because, again, you're still looking at what a person could believe under those circumstances. The example I've heard is if you see a robbery going down and you intervene to stop it, you shoot the attacker, it turns out it's a movie and everybody's actors, then you can look at the subjective, or look at the facts as as a person would have seen.
Completely different in that case, right? Because we're dealing with a subjective mental state.
I would submit that we're still, even to a reason to believe, I think you still look at what did he have reason to believe. And from all of the surrounding circumstances.
Once again, a subjective mental state about what he reasonably would have believed.
Or any reasonable person,
Okay.
given those facts. You put a reasonable person in that situation that's seen the prior history of consensual sex, his testimony that he did not see her take Ambien, the signs that he testified that suggested physical interest. I think even in that scenario, you could still say, well, what would a reasonable person think objectively given those facts, and end up in the exact same place? So I would submit that the law is not so limited on mistake of fact, even given the statute, to the extent that it looks at what a reasonable person, what a person could have believed.
A reasonable person.
A reasonable person, yes, Your Honor. You can still look at those facts.
And like that standard is not unique in the law, right? And so, I mean, we see the knows or has reason to know repeated often, particularly in sexual offenses. So this isn't a one-off, right?
I would agree with that this is, that the statute is not unique. But again, the case law, we've cited cases involving sexual offenses involving particularly the age of the victim, and was she above 13 or under 13?
None of those cases involve the alternative mental state of what a reasonable person would perceive or know under the circumstances, though.
Nonetheless, Your Honor, I would still submit, and I think I'm not sure if I have anything else to add other than my position. Yes, yeah.
I appreciate.
Again, I would simply, just say that my position is, looking at the mistake of fact offense again, you still look at even under a reasonable person standard, could those facts lead anybody to at least, does it fairly raise the prospect that there could be a mistake about that? And in this case, for the reasons in the briefing and that we've discussed, I would submit that even a reasonable person, given the facts that are in the record, in the light most favorable to Mr. Didomenico, could submit a view that he did not act with recklessness, which I think is the primary standard, whether he did know or had reason to know. The state has offered several responses, which did not include that, Your Honor, but as far as what the state has raised, one is that the jury did not accredit his testimony as seen by the verdict, which looks at the standard backwards. The question is, was the defense fairly raised based on the record at the time the jury was charged, in the light most favorable to the defendant? And they've kind of twisted it to really a sufficiency of the evidence standard of review, which looks and says, okay, the jury has made a finding, we look at the light most favorable to the state, but that's not the standard for a jury instruction question, because we don't know what the jury would have said had they been charged properly. They may well have thought, well, gosh, I think he really didn't know, but we find that she was incapacitated or did not consent. Well, that's why we have the instruction, so they can know that that is the appropriate result given that finding. So the fact that they ultimately convicted, that does suggest certain credibility findings in favor of the alleged victim in this case, but as far as just was it fairly raised in the light most favorable, does not at all answer that question. The state says that we needed expert testimony on the effects of Ambien, that we needed a doctor to come in and say that her behavior was consistent with somebody under the effects of Ambien. There is no case law that requires expert testimony to raise the mistake of fact offense, and in fact, in this particular case, both Mr. Didomenico and the alleged victim both testified how she had reacted on Ambien on a prior sexual occasion, and the facts are pretty similar as far as what she was able to do before what he observed to this incident, along with the fact that the alleged victim testified that even afterwards she was able to get up, go to the bathroom, get back in bed, and so she was not just completely passed out, behind the bushes somewhere. She was able to, her own testimony shows that she was indeed making decisions, making movements, things consistent with what he testified to. So I'd submit we did not need an expert to come in and basically say that all of what she herself testified to could have happened. And finally, the state argues basically that he just couldn't possibly have thought that she would have consented, and that's where they say he was still reckless, that under the facts, he just could not possibly have thought that, given the fact that they were in the divorce, that they had been arguing. But again, I would go back to the facts that we think fairly raise the defense. There was the prior history of sexual contact during these arguments. She showed the physical signs of consent, basically consistent with what he had seen before, and all of that, again, raised in the light most favorable to him from his testimony. I would submit that the case law presents a pretty low bar for the mistake of fact defense being raised. There was a case in Johnson where this court says that even when the defendant's position was far-fetched, even if it's far-fetched, that it still can be enough to get to that standard of being fairly raised. And I looked at the Jones case in particular, where the question is if the defendant knew if the alleged victim was over 13 when he lived with her, knew she was in the 6th grade. They celebrated her 13th birthday, and this court still said, well, it's at least fairly raised for him to be able to get that instruction in for the jury to make its own determination, and just to understand that that would be a defense if believed. And again, that's all we're asking for, just a jury instruction. The jury was certainly free to say, well, that's all well and good, we still don't believe it, but the jury still, he was entitled to have the jury have that instruction so that they could understand that that would indeed be a defense. And for those reasons, I would submit that the case law provides that this conviction should be reversed and remanded for another trial where the instruction is given, assuming that the testimony is the same as it was at the first trial. I'd also like to discuss our second issue regarding the evidence of the relationship between the alleged victim and her former client, which was a significant part of the state's case in chief that my client wanted the opportunity to essentially rebut.
The fact that she was dating him at the time of trial, how is that relevant to what took place at a time prior to that?
I would submit the circumstantial evidence surrounding all of that supports the idea that she was indeed dating him earlier. And I would acknowledge we don't have direct proof of that. We don't have a picture.
So if you don't have direct proof of it, you can't prove it. How does it go? I mean, you can't just ask, the rules don't allow you just to ask questions of a witness in order to cast doubt on their credibility without something behind them. I mean, I can't walk up to a witness and go, "You murdered someone on such and such date, didn't you?" when there's nothing to back it up, just so I can cast doubt to the jury that, hey, maybe they're a murderer. So if I have no proof that she's dating a former client at the time of this incident, how is it relevant that she's dating him now?
So I agree with the premise of your question that there does need to be some evidence, but I would submit we did have some evidence, more than just some evidence by circumstantial evidence, which is the case law is clear that circumstantial and direct evidence are both evidence.
What's the circumstantial evidence that you have of the relationship at the time of the rape?
So the circumstantial evidence at the time is first the text messages that my client says that he saw, that he testified that he said were more suggestive of than an attorney-client relationship. He said these are more than I would expect an attorney to be sending their client. It seemed overly personal, so that's thing number one, which by itself, I mean, that is certainly suggestive, even by itself. But then on top of that, we have in their divorce case, she says under oath when asked, "Are you dating anybody?" She says no. She has an ongoing duty to update that if that changes. And then
let's talk about that.
Okay.
I mean, in the civil case, it's not just an ongoing duty. You have a duty to seasonably supplement.
Yes.
She seasonably supplemented at some point.
Well, she did.
So are you asking us either to make a ruling in a civil discovery context, asking the jury to make some kind of determination that she failed to seasonably supplement under the rules of civil procedure?
No, Your Honor. I think we can look at it.
It only becomes relevant, right, if she's concealing it.
Yes.
And so it only then becomes relevant if she is failing to seasonably supplement. I mean, so if the trial court is looking at this and saying if the real evidence is whether she concealed, and so the real issue then is whether she failed to seasonably supplement, either I'm having to instruct the jury on the rules of civil procedure, I don't remember the rule, 2605 or what, 2607, or I'm going to have to give them a jury instruction on what the rules of civil procedure require so that they have in their mind the background to understand whether she truly is concealing. I mean, at that point, it seems like the trial court could say, I'm not going to try an issue about whether she failed to seasonably supplement under that. Its probative values outweighed by the danger of unfair prejudice or confusion of the issues, right?
So I agree with the premise of your question. However, I submit under the facts of this case, there was evidence for the trial court to make that finding that it was not simply a matter of a few months go by.
The criminal court is making a finding that a civil litigant failed to seasonably supplement a deposition response?
Because of the facts of this case, that it's not that just 6 months or even a year, even 5 years go by. The issue is what I find to be, what I think a jury could have found to be more than a coincidence.
Was there a corresponding finding in the circuit court?
I don't believe so. However.
Okay, so we're asking the criminal court to make a ruling on an issue of civil procedure so that from that there can be an inference of concealing evidence, but the criminal court is going to have to make the decision about whether her later supplementation was not seasonable?
I see my time is almost over. Would the court indulge me to go a little bit over
please.
to answer the question?
No, well,
Yes, Your Honor. I don't think that it turns on the intricacies of civil procedure and you have this many days. I don't think it turns on that at all. I submit that it's just like any other fact question that a court has to consider about the state of the evidence, looking at the specific fact in this case, that it's not that she simply waited too long, how long is too long, but the specific fact of this case that the thing that seems to prompt her to supplement, or at least the time at which she supplements, is only after she's caught going on a vacation with this person, coincidentally, the same person that the text messages involve.
So, Mr.
by
Redden,
my
I
client's.
thought we had agreed that the operative fact was that she was concealing the relationship.
Yes, Your Honor.
And so, let me go back to it one more time. If she's concealing the relationship, it can only be because she failed to seasonably supplement her deposition response, right?
Yes.
Okay.
But again, because
So
there's
it's not irrelevant. I mean, I think you started off the response to the question by saying that doesn't matter. It seems like it does matter.
I think it does matter, but I think, again, it's not just some intricacy of civil procedure. It's just a fact. If you just disregard, if we just say that there was no case, if it's just she gives an answer, she's supposed to supplement, and again, looking at the specific fact that it's not just that she changes at some point, it's only when she's basically caught going on vacation with this person and then she changes, I would submit that that is enough for a criminal court to make a finding regardless. I don't think that turns on intricacies of civil procedure, charging the law, having a discovery dispute of what civil procedure is, but just a common sense, circumstantial evidence. Was she concealing when she doesn't mention it until, again, she's discovered? And again, I think a jury could find that that is circumstantial evidence of concealment.
If she had no duty to supplement, would she be concealing?
Not necessarily. Again, other than looking at that
I
circumstantial
agree.
evidence.
Thank you.
But
Thank
Your
you.
Honors.
General?
Good morning. May it please the court, Lacey Wilbur on behalf of the state. And Judge Dyer, may I apologize for the lack of brevity in the brief. I did work for 2 days to get it down. And I enjoyed it no more writing it than you did reading it. But with respect to all, I just want to address the two issues that the defense counsel addressed, and I'll reserve and rely on my brief for the remainder of the issues, unless this court has any questions on those specific issues. With respect to the first issue, and a light most favorable to the defendant, which is the standard, mistake of fact was not raised by the proof in this case. This was a straight up he said, she said case. And what he said is she consented. He put his hand on her shoulder. She had the barrier pillow up. He testified that she had the barrier pillow up in the bed. And then, despite that, he testifies, he puts his hand on her shoulder. He says, "Is this okay?" She says, "Yes." He puts his hand under her shirt. He says, "Is this okay?" She says, "Yes." And then they proceed from there. There's absolutely nothing in the record to raise the issue of mistake of fact. And Judge Greenholz, I've never seen a case of spousal rape or date rape where mistake of fact was charged when it's straight up he said, she said, because again, it goes to your point that's the whole issue. It's province of the jury, which is a question of fact. Did the victim consent? That's the whole entire case.
I think my issue is really whether, as a matter of law, mistake of fact can possibly arise in this circumstance. I mean, the mens rea, it appears under the statute, has both a subjective and an objective component. So on the one hand, we do have a requirement that the defendant know of a particular circumstance, underage, incapacity. On the other hand, we also have an ability for the jury to find the defendant guilty beyond a reasonable doubt if the defendant reasonably should know. Well, that doesn't have anything to do with his subjective belief. And so with that, if a mistake of fact is related only to negate the culpable mens rea, the subjective mens rea, I don't see how it arises as a matter of law. And that was just the question that I was posing to your friend on the other side, just to see where that line of thought would go. Do you have any thoughts?
I did not think of that when I was writing the brief, but I agree with your analysis that
I mean, that's a non-model penal code mens rea. And so we have, part of the statute that we brought over from the model penal code says we've got 4 culpable mental states. This is an additional mental state that the General Assembly has added. It's added it to several of the sex crimes as it goes. I'm not aware of a case addressing mistake of fact in a situation like this. Are you aware of a mistake of fact in a situation like this being addressed?
No, Your Honor.
Okay.
No, Your Honor. And I just want to point out a couple more statements that the defendant made. He testified that when she took her Ambien, he noticed no difference in her behavior. He did get prodded and said, "Oh yeah, there was one time when she was very uninhibited," but he did not say she did not say yes or she did not say no. There's nothing in the record to say that that there's a mistake of fact. And at the very end of his testimony, he testified he 100% believed that the victim consented. So I just pose the question, there's no mistake of fact raised in this case, and the trial court did not err when it did not issue this jury instruction. If there are no further questions on that issue, with respect to issue 2, the trial court did not err when it did not permit the defendant to question the victim about whether she was dating another man at the time of trial. And if the court will just indulge me on dates, what we have here is the victim submitted her discovery response, signed it on August 12th, 2021. That was 2 days before the rape. The trial was in November 2023. She filed an amended response to her discovery response on January 4th, 2023. And in that response, she said she started a relationship with this man on June 2022. And I believe there's evidence in the record that she even testified under oath that she was not in a relationship with that man when she was married to the defendant. She did not start that relationship until June 2023. It has absolutely no relevance.
Well, it has some relevance, does it not, though? I mean,
I think
if she's claiming if she was claiming in the divorce proceeding, one of the bases for the divorce was, or part of that was the arguments they had and him accusing her of having a relationship with this other person, right?
Yes.
Okay. So, I mean, tenuous at best. But I mean, there is some relevance if that's one of the bases for the arguments they were having and maybe why they were on again, off again prior to the divorce and even after divorce papers were filed. Maybe she was in a relationship with someone else and maybe didn't want him to know that about the husband. I mean, could you not see where at least being able to ask the question? She can deny it, right?
Yes.
He could ask the question because he does have something. He has the text messages. So, were you in a relationship with Mr. X? Yes or no is the answer, and then you move on. Is there not some relevance there?
There might be relevance, but the danger of unfair prejudice, and it just has no weight going to the issue that is the crux of this case is, did she consent? And I said in my brief, the fact of whether she was in a relationship, that could have actually hurt the defendant more than helped the defendant, because that would be a reason for him to have revenge sex or something. But the trial court properly exercised the discretion when it said the probative value of that was very slight and the danger of unfair prejudice outweighed any of that probative value. And again, she would have said no, but we do have him under oath. He did manage to slip in and said, I saw these text messages and there were winky faces. So it wasn't that it was not totally before the jury, but the trial court did not abuse its discretion when it did not allow, because it was irrelevant.
So in one of the pretrial hearings, the court mentioned 412. There's not a Rule 412 issue in this case, is there?
No, sir.
Okay, all right. And to say that with the trial court, I think in the later holding, it didn't reference 412 at all, but it had popped up, and I was curious.
Yes, sir. In a pretrial hearing, he did say he referenced it, but it was not.
Right, it's not part of the court's ultimate ruling. It's a strict 403 analysis.
Correct. Yes, Your Honor. If this court has no further questions and no further questions on any of the other issues presented in this case, I'll just stop and I'll ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
Thank you.
Thank you.
Mr. Rabin, since Judge Greenholtz took up a lot of your rebuttal, I'll give you your 3 minutes back. How about that?
I wanted to address a few points made by the state. For my timer, there we go. As far as the fact that the defendant did testify that, consistent with his belief, she was consenting and he believed that she was consenting, my position again is that does not negate the possibility that he could have been mistaken. The case law does not require a defendant to come in and say, I could have been mistaken, I don't know, because if they testified to that, that would almost suggest that their mistake was
Well,
not
let
reasonable.
me ask you the question in this way. The state points out, and I think Judge Greenholtz asked the question as well, do you know of a other spousal rape or just a rape case that's a he said, she said case, as described here, in which mistake of fact was given or the court has said it should have been given?
I'm not aware of one, but I think this case has some pretty unique facts here where, again, we have the on and off again relationship that makes it more likely that, again, she would have consented on this time, and the whole ambient issue. She says, he saw me take it, he says I didn't, and that is a complete game changer. It's really the whole case, is was she on Ambien or not? Because if she wasn't, that would matter. And it also makes his potential mistake more likely, because to the extent that he says she's moving and doing all these things that she can't really say, I don't know if I did or I didn't, again, that is consistent with what the undisputed testimony was of how she had acted on a prior occasion. So I think this case just has some very unique facts here that may explain why this normally doesn't come up, because I think in most rape cases it doesn't necessarily come up with these particular issues. As far as, additionally on that point, he testified that he believed there was consent. But again, I would return to the counsel's argument, opening and closing statement. The issue in this case is what he believed. And defense counsel even said, you could believe her, but that's not what this case is about. I mean, having seen all the proof, he's making his closing argument. It was a different attorney than myself. When I say he, the defense counsel, even with all that proof, he's really arguing a mistake of fact defense. You could believe her, and my client should still be acquitted, but without that instruction, then the jury just did not have anything to do with that to know, okay, if I truly believe that that's what happened, then I can acquit, which is what the instruction should provide. As far as the issue with the boyfriend and the relationship, just briefly on that in my remaining time, I would just reiterate, the state brought this issue up as far as he overreacted. That's why I filed for divorce. That's why I would not have had sex with him, because it was so irrational that he would have thought I was in a relationship with this person. And out of 4 billion men on this earth, she ends up dating that exact same former client and only discloses it after being caught in an airplane by my client's sister. And at some point, I think a jury could have at least been presented with that. I'm sure she would have denied it. I'm sure she would have said, no, it just coincidentally happened later. But at some point, when the state opens that door, the defense was allowed to present that proof on. Thank you.
What about, I'm sorry, real quick, what about the fact that she did testify under oath, whether it was a proffer or not, that this is when it started? Does that weigh into the court's decision of whether or not to allow the testimony? If I have someone testify under oath that I believe, let's just take that as the hypothetical, I heard her testify, I believe her, does that end the question at that point if he makes that credibility determination that it didn't happen then, so it only happened afterwards?
I think, again, you have to look at the whole circumstance. It's circumstantial evidence. Obviously, I think there is a point at which a court could make a finding. I absolutely believe her, no matter what. The rest of it, it's just coincidental. I mean, I think at some point the court could make that finding, but I don't believe the court did make that finding. And without having made that finding, I would submit that the evidence should have come in.
Okay, thank you. All right, thank you, both sides. We will take this under advisement. And with that, we will take a few-minute recess so we can swap out some judges here.